In this new series of videos, I'll be discussing some model questions on contract law. This is based on the International Advanced Level Law syllabus, but I hope generally this would be useful for anyone following contract law as a subject, as I'll be discussing some basic principles of contract law and how you can apply that in problem questions. So let's move on to the first question. You can pause the video and have a look at the question, read the question properly, identify the parties and the incidents that have happened so that we can move on to see how to answer this question. So to explain you briefly what has happened in this question, there are two people, Sarah, who is the owner of a shop, and she has displayed a handbag for the price of 250 pounds. And Priyanka is coming to the shop to buy this handbag, and she is asking Sarah whether she can get the handbag at 200 pounds. And Sarah is saying that she can only sell it to 220 pounds, but Priyanka disagrees and she walks away. After 2 days, again Priyanka comes back to the shop and she is asking whether she can buy the handbag at 220 pounds. But at this point, Sarah is saying that she has decided not to sell it. And again, another person named Sita is walking into the shop and she is expressing her willingness to buy the handbag at the original display price, that is 250 pounds. But here too, Sarah is disagreeing to sell the handbag. So then the issue here is whether Sarah is bound to sell the handbag either to Priyanka or to Sita. We need to answer this question and let's see how we do it. So when answering contract law questions, the main thing that you need to understand is there are 5 elements that are essential for a legally binding contract. So these are offer, acceptance, consideration, capacity to contract, and intention to create legal relations. So in examination questions, you'll be tested either all these elements, but most of the time they will select some elements like offer and acceptance or just consideration or capacity. They will pick and choose some of these elements and question you on the problem questions. So it is up to you to identify which elements are at issue in a given question. So if you take the question that we just read, we can see the main issue there is where is the offer and whether the offer is accepted. These are the two questions that we have to attempt to answer, and we can see that there is no issue related to consideration, capacity, or intention to create legal relations in this particular problem question. So likewise, when you get a question, identify which elements are at issue and you need to discuss those issues and provide answers for those issues, and you don't need to describe all the other irrelevant elements in your answer. So let's move on to the different incidents that have happened in this question. Firstly, you have to identify whether the display of the handbag in the shop window with the display price is an offer or not. We know that it is not an offer but only an invitation to trade. What is an invitation to trade? It is an invitation to make an offer rather than being an offer itself, and it contemplates further negotiations taking place. You can refer to the two authoritative cases, Fisher and Bell, and also Pharmaceutical Society of Great Britain and Boots. These two cases are authority to say that display of goods in a shop window is not an offer but only an invitation to trade. So referring to these two cases and explaining what an invitation to trade is, you can come to the conclusion that Sarah is inviting customers to make offers to purchase the handbag, but she is not legally obligated to sell at the price displayed because it is only an invitation to trade and not an offer. Moving on to the next situation, Priyanka, who comes to the shop, is indicating her willingness to buy the handbag at 200 pounds. Is this an offer? Yes, it is. What is an offer? Explain that. So, offer is an indication of a party's willingness to enter into a contract with the party it is addressed to as soon as the terms are accepted. So, the terms of an offer must be clear, definite, and unambiguous, and it should indicate the willingness to be legally bound, as held in the case of Storer and Manchester City Council. Then we can come to the conclusion that Priyanka's willingness to buy the handbag at £200 is clear, definite, and unambiguous, and she shows her willingness to create legal relationships. She is willing to be legally bound, so we can consider it as an offer. Moving on, Sarah responds to this offer saying that she can only sell the handbag at £220. Is this an acceptance? No, it is not. She has not accepted Priyanka's offer because acceptance should be a mirror image of the offer. You can't change the terms of the offer and accept it. So there is no acceptance here, but Sarah's response is only a counter offer. What is a counter offer? You can refer to the case of Hyde and Wrench and explain what a counter offer is. It is a response given to the initial offer, which rejects the original offer and replaces it with an alternative offer. So here, Sarah is rejecting Priyanka's offer to buy the handbag at £200, and she's replacing that with an alternative offer that is to sell the handbag at £220. So has this counter offer been accepted by Priyanka? No, she has not. She rejects the offer and she rejects the counter offer and she walks away from the shop. So there is no legally valid contract up until this point. And 2 days later, she returns back to the shop and tries to accept the Sarah's offer to sell at £220. But at this point, Sarah is not willing to sell it. So the question is whether Sarah is bound to sell the handbag at the price that she offered earlier, that is £220. Here we need to refer to the law on revocation and see whether Sarah is bound to sell the handbag or not. If we refer to the case of Dickinson and Dodds, it clearly says that the offerer may revoke or withdraw an offer at any time before acceptance takes place. So earlier, 2 days before, Priyanka rejected the offer, so there was no acceptance. That means the offerer has the freedom to revoke the offer anytime before acceptance takes place. So that means Priyanka has initially rejected Sarah's offer. Therefore, Sarah is free to refuse to sell at £220 when Priyanka returns later. You can also use the case of Ramsgate Victoria Hotel and Montefiore, where the court said that an offer will terminate after the expiration of the express time limit or after reasonable lapse of time. So here there is a reasonable lapse of time because for 2 days, Priyanka has not accepted the initial offer. So by 2 days, Sarah is free to revoke her offer and she is not bound to sell the handbag at £220. Moving on to the next situation where Sita comes in and shows her willingness to buy at the marked price of £250. So is that an offer? Yes, it is. But if there is an offer, we have to find whether there is an acceptance. There is no acceptance. Sarah does not accept it. And the question is she bound to accept it because she has put the handbag on display with the price tag of £250? No, she is not bound to accept it. An invitation to trade is just an invitation to make offers. It does not mean that you're obliged to accept the offers that are made. So there is no legally binding contract either with Priyanka or Sita. So we can say Sarah is not bound to sell her handbag to both of these people. Always remember when you're writing answers for contract law questions, come to a conclusion. You may have explained everything within your answer, but it's very important to write one or two sentences explaining your conclusion. So here you can say, Sarah is not legally obligated to sell the handbag to either Priyanka or Sita as there is no legally binding contract. So this is how you have to answer problem questions. This is just a simple question. You will get more complicated questions than this. So this is just the beginning. I will discuss more of these questions in the coming videos. So stay in touch. And if you have any other comments or questions, put them in the comment section. Thank you.